אוקיי.
בואי נוודא שהצ'אט מוגבל.
זה כבר ריקורדינג, אני לא...
I hate burning.
Distinguished experts, dear colleagues, I would like to welcome all of you to this side event. My name is Valérie Lebeau from UNODC Crime Prevention Criminal Justice Section. This side event is organized by Israel with the support of the Center for the Global Study of Wrongful Convictions at the Ohio Innocence Project, the Innocence Network International Committee, and my section, UNODC Crime Prevention Criminal Justice Section. I am very honored to moderate this exchange of experiences on how to address wrongful convictions under national and international law. This relates to the overarching goal of UNODC work on justice reform, namely, to ensure that criminal justice systems are fair, humane, and efficient, which includes that everyone should have equal access to justice without discrimination, based on international human rights law and enshrined in Goal 16 of the 2030 Agenda for Sustainable Development. The purpose of a criminal justice system is to uphold, preserve, and protect the rule of law. The Kyoto Declaration, adopted by last year's United Nations Crime Congress, reaffirmed the responsibility of all states to fully promote and protect all human rights and fundamental freedoms, as well as to uphold the principle of human dignity in the impartial administration of justice and throughout all our efforts in preventing and combating crime. According to international human rights law, as well as to the UN standards and norms in crime prevention and criminal justice, of which UNODC is a guardian. And let me mention here the United Nations principles and guidelines on access to legal aid in criminal justice systems and the Nelson Mandela rules on the treatment of prisoners. According to those instruments, persons who are accused of or charged with a criminal offense should receive a fair trial and be treated humanely when imprisoned. This includes providing them access to legal support, and this includes access to legal aid where a person does not have a means to pay for a lawyer, or in cases where the interests of justice so require, and this at all stages of the criminal justice process: the investigation stage, trial proceedings, appeals proceedings, and post-conviction stages. In all regions, it can happen, and it does happen, that individuals accused of having committed a criminal offense do not receive fair trials or are convicted and sentenced to imprisonment with judgments based on mistakes made in the collection and analysis of evidence or other reasons linked to faulty criminal justice processes and procedures. Wrongful convictions violate the fundamental rights guaranteed to every citizen. They damage trust in the justice system and undermine one of the fundamental principles and legal values of criminal law, the presumption of innocence. This panel will discuss the challenging issue of wrongful convictions and their causes, the expansion of innocence work across the world in the past decade, and the pressing need to address this issue in international fora. This event will be recorded to benefit those who are unable to join us today. You are most welcome to use the Q&A function of your Zoom application so that our panelists can read your questions and react to them. We also have planned for some time left at the end of the speaker's time to respond to questions from the audience. And now I am looking forward to the presentations of our distinguished experts who will discuss these developments in light of the Kyoto Declaration's commitment to access to justice and equal treatment before the law and access to legal aid. Allow me here to thank in particular all the speakers joining from North America in the middle of the night. Thank you so much. And now let us start with Professor Lawrence Helfer from Duke University School, who will share his views on closing international law's innocence gap. Professor Helfer, you have the floor.
Thank you very much, Valerie, and thank you all for organizing this panel and for those attending. We look forward to your questions and having an informed conversation. This paper began a few years ago with a dinner conversation among 3 academics with different professional backgrounds in international law, human rights, and domestic criminal justice. The conversation led to the recognition that the rights of defendants to assert post-conviction claims of innocence were insufficiently protected in international law, and that national level developments recognizing these rights, which you'll hear more about from the other panelists, have occurred with little help or influence from international law. In particular, although human rights treaties recognize extensive fair trial and appeal rights, no international instrument in its text, in its interpretation, or its implementation fully and explicitly recognizes the right to assert a claim of factual innocence. Our paper labels this omission as international law's innocence gap. I see you have a link to the paper in the chat. And we see this gap as increasingly incongruous given how foundational innocence protection has become at the national level, and in light of international law, human rights law's longstanding commitment to the presumption of innocence, fair trial, and other criminal procedure guarantees. Our paper argues that in favor of closing international law's innocence gap and recognizing at an appropriate time and in an appropriate way a new human right to assert post-conviction claims of factual innocence based on newly discovered evidence. Now, I should say a word about how such a claim might be recognized from a normative perspective. The paper identifies 2 potential pathways, which we label as the derivative rights approach and a freestanding rights approach. Both of these processes have established precedents and pathways in international law and have led to the recognition of new rights such as the right to water, the right to environment, LGBTQ rights, and others. And our paper aims to show that the right to claim innocence can be defended either as derived from several established human rights guarantees, as I mentioned, the right to life, fair trial, appeal, and remedy, right to compensation for miscarriages of justice, or as a freestanding right. In the interest of time, I will focus in on the derivative rights approach, which proceeds from the premise that international human rights treaties are quite specific and detailed in certain areas of the criminal legal process. These guarantees taken together establish a baseline of protection that has influenced all legal systems. And I should say that framing a particular criminal justice guarantee as a right has a number of benefits, strategic, normative, enforcement, and symbolic, that I think show the influence of this kind of framing. However, features that are central to meaningful review of post-conviction innocence claims that exist at the national level in different forms, although not uniformly across all jurisdictions, these features are strikingly absent from existing international rights guarantees. For example, some of the absences include the obligation of governments to establish some sort of mechanism, whether judicial or administrative, for defendants to introduce evidence of innocence on direct appeal or after a conviction has become final. Also absent are evidentiary standards that are applicable in such proceedings. Who bears the burden of proof? What is the appropriate quantum of proof? And so forth. Finally, also missing are provisions for adequate remedies to individuals whose innocence claims are upheld. A few human rights treaties do recognize a right to compensation for miscarriages of justice, but that is only a partial remedy, and it only exists in certain international agreements. So there are significant gaps, and there are real opportunities to try to close those gaps. However, there is some indication in various parts of the international human rights system that there are efforts underway to remedy some of the omissions I just mentioned. And in the interest of time, I will focus on simply one of them. And that is the UN Human Rights Committee's general comment from 2018 on the right to life, in which this treaty body, expert body that reviews implementation of the International Covenant on Civil and Political Rights, for the first time recognized an explicit link between wrongful convictions, post-conviction review, and the right to life. And the committee urged all states parties to take all feasible measures to avoid wrongful convictions in death penalty cases, to review procedural barriers to reconsideration of convictions, and to re-examine past convictions on the basis of new evidence, including new DNA evidence. This statement is especially noteworthy for moving beyond the procedural guarantees that support legal innocence claims to focus on how states should respond to defendants who allege claims of factual innocence. So this is only one example of our argument that core principles underlying existing case law and jurisprudence of international human rights bodies provide a strong foundation for affording individuals who assert claims of factual innocence a right to a meaningful opportunity to assert those claims, and for an appropriate body, judicial, administrative, or otherwise, to grant appropriate relief if the claim is upheld. I'm happy to say more about these issues in Q&A, but in the interest of time, I will stop here. Thank you very much for your attention.
Thank you very much, Professor Helfer, for outlining pathway to close the innocence gap under international law, namely to establish or guarantee the right to assert claims of innocence, especially post-conviction, and that not only on procedural grounds, but also on factual grounds. Thank you very much for this very clear presentation. And now I would like to give the floor to our next speaker, Professor Justin Brooks, who is the director of the California Innocence Project, as well as director of the Instituto Latinoamericano de Derecho y Justicia. And he will talk about innocence work across the United States and Latin America. Professor Brooks, you have the floor.
Good morning from California, where it's 4 in the morning. My name is Justin Brooks, and I've been litigating wrongful conviction cases for nearly 30 years. I've worked on both sides of the border, both in the United States and also in Latin America. My work in Latin America began 25 years ago when I had the honor of training the first 12 public defenders in post-Pinochet Chile. And today I want to talk about innocence work in the Americas. In the United States, this past year, we passed a landmark number of 3,000 documented cases of wrongful convictions. These were 3,000 people who lost years of their lives, 3,000 judges who thought they were putting the right person in prison, tens of thousands of jurors who believed incorrectly that they'd convicted a person who'd committed a crime, and they were all wrong. Looking at these 3,000 cases, we've learned a great deal about the causes of wrongful conviction. The innocent people whose lives were devastated were convicted based on such things as bad identifications, false confessions, false informant testimony, government misconduct, bad lawyering, and a host of faulty forensic sciences that we've been able to identify and are attempting to remedy. I have personally walked 35 innocent people out of prison based on one or more of these causes. One of my clients was a 21-year-old innocent woman who had been sentenced to death without any investigation into her case and without even having the benefit of a trial. The problem of wrongful conviction is not limited to the United States because the causes of wrongful conviction are universal problems. Bad identifications are largely based on the frailty of human memory, and that is something that all humans suffer. False confessions occur the world over, where officers are not trained to discover the truth, but instead to confirm their own predetermined conclusions. Every system in the world, every criminal legal system has some amount of corruption. Every system in the world has competent judges, lawyers, and police officers, and every system has incompetent ones. And the forensic sciences that we've seen that are faulty have infected criminal trials around the world. Because these problems are universal, procedural rights are needed throughout the world that enable wrongfully convicted people to bring their claims to court and prove their innocence. It was 30 years ago when the miracle of DNA technology first appeared in our criminal courtrooms, and it put a mirror to the criminal legal system that revealed its many, many flaws. And today it continues to reveal flaws in all of our systems. So in the United States, there's a right to a lawyer at trial and to handle an appeal after the trial. But that right disappears after the trial has been reviewed for errors through our appellate process. Many of the 3,000 people who were exonerated had their innocence proven years after their convictions and their appeals terminated. and innocence organizations took up those cases and reviewed them. I'm proud to have co-founded one of those organizations, the California Innocence Project, which began its work in 1999. And I'm also proud that I founded Red Inocente 10 years ago, which is an organization that has now launched 32 innocence organizations in Latin America. But these organizations are not enough of a safety net. Most of them have extraordinarily limited resources, only being staffed by law students and a handful of public interest lawyers. And that's not enough to deal with this problem. Over the past few decades, we've fought state by state in the United States to bring reforms to the criminal legal system, to decrease the number of wrongful convictions, improve the ability to bring innocence claims, improve post-conviction processes, and make it possible for wrongfully incarcerated people to obtain compensation from the government. The battles have been long and arduous, but have resulted in many new laws and policies that require, for example, preservation of evidence after trial, the right to post-conviction DNA testing, reforms in the way identifications and confessions are obtained, compensation for the innocent, new standards of evidence. But national reforms are difficult in the United States because most criminal laws at the state level and most criminal justice policies are actually formed at the county level. So we see an inconsistency from jurisdiction to jurisdiction, with many systems that are left not far from where we were 30 years ago. In Latin America, the challenges in reversing wrongful convictions are more profound. While there have been breathtaking reforms over the past few decades, most recently the movement in Mexico to oral trials and an opportunity to cross-examine witnesses and evidence, the procedures for reversing wrongful convictions are woefully inadequate. The resources are even more limited than the United States. I've spent the past 8 years training lawyers in Mexico how to conduct oral trials, but with public defenders handling more than 500 cases at a time, there's not the attention to detail that's needed to avoid wrongful convictions. And even with time, unfortunately, the education system in Mexico, with more than 2,000 law schools, is still not teaching students sufficiently how to litigate effectively in their new trial system. Compounding this problem is the amount of corruption in the criminal legal system throughout Latin America. This corruption permeates the criminal legal process from arrest through to sentencing and often leads to wrongful convictions of the poor and the powerless. I've spent far too many hours of my life sitting in prisons and explaining to innocent people the difficulties of gaining their freedom and sitting in the living rooms of their loved ones explaining the same. The right of innocent people to be free from incarceration is fundamental. It should be recognized and policies and procedures enacted to make their freedom a reality. Thank you.
Thank you very much, Professor Brooks, for sharing your extensive experiences across the US and Latin America of reversing wrongful convictions, sharing your reflections of the on the causes for such wrongful convictions, identifying progress made in reform, including through your own project, Innocence Project, and identifying also all the remaining challenges. Thank you so much. And with that, I would like to invite our third speaker, Professor Marc Godse, who is Professor of Law and Director of the Ohio Innocence Project. And he will be speaking about the fight for innocence in Europe and in Asia. Professor Godse, you have the floor.
Thank you very much. Like Justin, I run an innocence project in the United States. I'm a professor of law at the University of Cincinnati College of Law and founded the Ohio Innocence Project in 2003. Our organization has now freed 34 Ohioans who together served 675 years in prison for crimes they didn't commit. And the way that the innocence movement has grown in the United States, we're all sort of independent innocence projects, but at some point in the early 2000s, we joined together and formed a network for information sharing and conferences and sort of to solidify, the little power we were gaining in each state. And we realized at one point that we needed to, form this network, and then we created a board of directors. So these are people like Justin and myself who run innocence projects who get elected to sort of help form the policy of the national movement. And pretty early on, by like 2005 and 2006, we realized that within this board, we needed to form an international committee, which Justin and I were the first co-chairs, and we've chaired it ever since. And the reason that this became obvious was that we were all getting inundated with requests from lawyers and scholars and activists from every single continent saying, oh, I just saw this newspaper article about you freed this person, and this kind of evidence was used, and my goodness, we have the same problem in my country. We use the same type of evidence, and I believe there's people wrongfully convicted, and can you help me? And these requests were coming in at such a quick rate that we needed to form a committee to start fielding them. And around that time, I created sort of a subpart of my innocence project called the Center for the Global Study of Wrongful Conviction, which began sort of sponsoring conferences in different parts of the world, so that we get people together and do this consulting and explaining and educating, which we've now sponsored numerous conferences. This energy, we were sensing this sort of thirst and hunger from scholars and lawyers all around the world, just eager for this information because they believed they had the same problem, that we decided to have a conference in 2011 in Cincinnati, and we sort of put the word out that this is going to be the first International Innocence Conference. And we had over 500 people show up from 26 different countries, where we all sat together in a room and for several days and talked about all these problems, and started realizing, look, we all use the same type of evidence. All these innocent people who have been identified in the United States based on certain types of faulty evidence are what's used around the world. And since that time, the movement has really started taking off in different forms. Justin described what's going on in Latin America. And just in the past 10 years in Europe, numerous innocence projects have sprung up, and in recent years they formed a network and started having their own sort of regional conferences. You have the Netherlands with Knoop's law firm, which actually has had numerous exonerations. You've got innocence projects in Italy. There's one at a law firm in France and Spain and Poland. There's one starting in Sweden, Ireland, several in England. And every time there's a conference, there's new people coming from other parts of Europe saying, look, we got to get involved in this. We have this problem as well. But, there's been some, like Justin described in Latin America, problems with getting it to the sort of robust level that we have it in the United States. Number one, when we started in the United States, the system was very resistant. Oh, we don't make mistakes in this country. We have a great criminal justice system. They're very unfamiliar with the idea that they could have wrongfully convicted someone. And then 30 years later, we still have that problem. Obviously it's gotten better, but anytime the movement starts somewhere, you have people in power who are very resistant to acknowledging a mistake. And in Europe, there's a couple of things that have held it back compared to the United States. In the United States, the innocence projects are based at law schools, where it's law schools and attorneys, and often volunteer attorneys, who are using these law students. There's a lot of free labor from these students who are getting class credit. And there's not that tradition of clinical law school work in many of the European countries. So, it's just not part of their tradition. And so the idea of introducing this and creating this infrastructure that was already sort of pre-existing, this notion of having law clinics in the US where students, work on causes with their professors and they litigate, that's been longstanding for decades in the US. It doesn't exist in many other places in the world, which has made it more difficult. You have legal aid, but most of these legal aid, no matter where you are in the world, doesn't extend to post-conviction. And so what it's ended up being is, in Europe, often just these, good-hearted activists, lawyers who are just trying to do it themselves, or law professors at law schools who do not have this clinical tradition, and therefore they don't have sort of the built-in infrastructure that, for example, I have at my school, where we have a whole clinical component and we can just turn all that energy toward investigating and litigating Innocence Project cases. And so, you know, there have been exonerations, but, you know, the amount of effort it takes not only to get an exoneration, but to change the laws. I mean, you look at how hard it's been in the United States. We have a very robust movement. We have this clinical experience where 30 years later, we've made numerous changes in the domestic state laws to remedy the situation, but it's a huge, massive effort. The infrastructure of the Innocence Projects, where it's like, you know, sole law firms or very, you know, just a few professors at a law school working with a few students without the infrastructure, makes it extremely difficult to lobby and educate and make the changes necessary to get this off the ground. But one thing that we notice anywhere in the world where an infrastructure does manage to pop up and you have sufficient resources, they start getting exonerations. It doesn't matter where it is. So, for example, you know, one of the I'd say most robust projects in Europe is Knoop's in Netherlands, and they're able to get people out of prison and prove them innocent. So the problem is literally just the infrastructure and the ability to change the laws and the lobbying necessary. So in Asia, it's been a very similar experience where in the last 10 years, Innocence Projects have popped up in numerous countries. There's a very strong Innocence Project in Taiwan that's had numerous exonerations, including some from death row. In 2016, the Innocence Project launched in Japan. There's one in Singapore. There are attorneys who are doing this work in South Korea, in Thailand, in the Philippines, in India. Again, we're constantly being inundated on our committee with questions and, you know, consulting with people in these countries on these issues. In 2018, the Asian Innocence Network had their first conference where they all came together in Taiwan and discussed these issues and the commonalities, and sort of vowed that they were going to try to work together going forward. But of course, COVID hit. And in China, you know, there's not an Innocence Project in China, but there's been many public exonerations of people who spent many years in prison. And they're very concerned about the issue. I've personally attended several conferences there and met their exonerees. And this is something they're putting a lot of focus on. And they've actually made some domestic criminal procedure rule changes in recent years to combat this problem. Then you look at a place like the continent of Africa. For a while, there was an Innocence Project in South Africa at the Wits School of Journalism. And it was fortunate to have sort of the infrastructure of many of the projects in the United States. And because it did, it was able to get many exonerations in its time of existence. But then it closed during the pandemic, as did a lot of things. But, you know, Justin and I talk all the time, and I think Justin's been fielding the questions from Africa. You know, there's not the infrastructure, there's not the resources for them to create these NGOs like we have in the United States. So it's up to individual lawyers who have these concerns and want to bring these cases. And so we get calls and emails from them and end up trying to talk through with them how you do one of these cases and how you prove your client innocent. But once again, they don't have the domestic laws. They're woefully inadequate in most places. And so, you know, no matter where you look in the world, you can see numerous things. You can see, one, legal aid is lacking for post-conviction. The resources aren't there. It takes a massive infrastructure to get the kind of changes needed. And also where it does exist, you do see exonerations. I'm happy to take further questions during the Q&A period, but that's all for now. Thank you.
Thank you very much, Professor Gotze. Thank you for sharing how a national US network of innocence projects became a global movement for information sharing and mutual support, and how subsequently this led to the establishment of regional networks in Europe, in Asia. Thanks for underlining the importance of a strong infrastructure, which in the US exists based on the clinical tradition of law schools, and also for the importance of this movement to obtain not only exonerations, but also legal reform. And Now I would like to introduce as the last speaker on this panel, our long-term partner and friend in promoting access to justice through legal aid across the world, Dr. Anat Horowitz, who is the Deputy Chief Public Defender of the State of Israel. And this will conclude the event with a highlight on the role of legal aid providers in reducing wrongful convictions. Dear Anat, you have the floor.
Thank you, Valerie. I'd like to begin by apologizing for the technical issues we had at the beginning of the session, which did not enable me to hear all the opening remarks, and I'm very sorry for that. I'm truly delighted that this event is taking place and would like to thank the Crime Prevention and Criminal Justice section of the UNODC for co-organizing this event together with the State of Israel, and to express my gratitude to the Innocence Network and to the Ohio Innocence Project for the support of the event. My name is Anat Horowitz, and for the past 10 years, I've had the honor of serving, as Valerie just mentioned, as the Deputy Chief Public Defender of Israel. In this capacity, I've witnessed on a daily basis the challenging and essential role of close to 1,000 Israeli public defenders in criminal proceedings, and I've come to appreciate the critical mission of all legal aid providers around the world to ensure their clients' access to justice. It is from this perspective that I will address the issue of wrongful convictions and the promises and pitfalls of the current legal situation, with particular focus on international instruments addressing legal aid, and I will begin with the latter. Legal aid has long been the focus of, or a focus area in the UNODC's work on crime prevention and criminal justice. Indeed, work on issues related to the right to due process began much before member states of the UN adopted the Sustainable Development Goals in 2015, including Target 16.3 that I believe was mentioned at the beginning, that seeks to promote the rule of law at the national and international levels and ensure equal access to justice for all. In accordance with this target, in recent years, UN bodies, and in particular the department headed by our distinguished moderator, intensified their efforts to develop meaningful tools and provide assistance in establishing and strengthening legal aid agencies. One of the earlier yet extremely significant resolutions in this respect was adopted by the General Assembly on December 20, 2012. Resolution 67187 declared that the United Nations principles and guidelines on access to legal aid in criminal justice systems, which I'll hereinafter refer to as the principle and guidelines, that was annexed to the resolution was a useful framework to guide member states on the principles on which a legal aid system should be based. Moreover, the resolution invited member states to adopt measures to ensure that effective legal aid is provided in accordance with the spirit of the principles and guidelines, and encouraged member states to consider the provision of legal aid to the maximum extent possible. So what is the spirit and principles on which a legal aid system should be based according to the principle and guidelines? So naturally, within the scope and time limitations of this event, I will not answer the question in full, but rather focus on two sections that are relevant to the issue on hand, namely wrongful convictions. According to Section 3 of the introduction of the principle and guidelines, a functioning legal aid system, as part of a functioning criminal justice system, may reduce the length of time suspects are held in police stations and detention centers, in addition, and I stress this part, to reducing the prison population, wrongful convictions, prison overcrowding, and congestions in the court. Therefore, according to the principles and guidelines, an important contribution of functional legal aid organizations to criminal justice system is to reduce wrongful convictions. How can wrongful convictions be limited? by having legal aid providers attempt to prevent them in the first place, and of course to allow them to assist the wrongfully convicted in claiming their innocence after the proceedings have terminated. The principles and guidelines, however, don't stop here. Guideline 11 refers to nationwide legal aid systems, and sections 50B within this guideline explicitly declares that in order to encourage the functioning of a nationwide legal aid system, states should, where it is appropriate, undertake measures to provide legal aid to persons who have been unlawfully arrested or detained, or who have received a final judgment of the court as a result of a miscarriage of justice in order to enforce their trial to retrial, in order to enforce their right to retrial, reparation, including compensation, rehabilitation, and guarantees of non-repetitions. In light of these sections, what is the significance of the principle and guidelines to our role as public defenders vis-a-vis wrongful convictions? And more broadly, what can we learn from the aspiration of the principle and guidelines in section 1 to promote a fair, humane, and efficient criminal justice system that is based on the rule of law? Under Israeli law, legal assistance may be provided to convicts who claim their innocence and seek retrial. However, as we've previously heard from Professor Brooks, this is not the case in most countries, and even in countries that do have legal aid providers, they're often overburdened and do not have the resources in order to properly represent these persons. Given the state of affairs, it's not surprising that much of the impressive accomplishments of the innocence movement in the United States, as we heard from both Professor Brooks and Professor Gotzi, have been achieved through university clinics or other private organizations rather than legal aid providers. Thus, in many countries around the world that are deprived of such organizations, wrongfully convicted persons are often left to their own devices. And it hardly needs noting that lack of legal representations add additional and significant barrier to exoneration atop the many others that were partially mentioned by my colleagues. It is important to stress that also in Israel, where convicts, as I mentioned earlier, claiming their innocence may receive legal aid, we are more often than not unable to assist our clients. In the 74 years of the existence of the State of Israel, only 35 requests for retrial were actually granted. And of these claims, only 23 convicts were fully exonerated. In our jurisdiction, as elsewhere, claims of innocence are extremely difficult to substantiate due to negligence in the preservation of evidence, the lack of a clear and comprehensive right to post-conviction testing of evidence, a rigid adherence to the finality of the proceeding principles, and many other previously mentioned obstacles. So the bottom line, which will also end my short presentation, is that we would like to use this opportunity to echo the call coming from the trenches of legal aid providers who are firsthand witnesses to the inevitable tragedy of wrongful convictions and the unimaginable price paid by the persons and the families affected by them. The essence of this call is similar to what we heard in previous presentations, but based on the perspective of the public defense and the resolutions adopted by United Nations, including the important work undertaken by the UNODC in respect to legal aid. The essence of the call is a desperate need to uphold the promise included in the principle and guidelines, and to ensure under international law the provision of legal tools to properly represent the persons that we were asked to take care of, and who have received the final judgment of the court, as the words of section 54B state, as the result of a miscarriage of justice in order to enforce the right to retrial, reparation, and including compensation. Thank you very much.
Thank you very much, Anat. Thank you for sharing your national experience and for analyzing the relevance and the usefulness of the UN principles and guidelines on access to legal aid in relation to wrongful convictions, their prevention, their reversal. Thank you. And thank you again for taking the initiative of this very useful and instructive event. And now we have taken a look at the chat, and one question which could be answered by any of our distinguished speakers is about a question on the role that ordinary citizens can play to support the innocence, the progress of this innocence movement. So does someone want to begin with that question, and then I will turn to a second question that was set.
Well, an ordinary citizen, you know, if there's a local project in that jurisdiction, reaching out to them and finding out what they need help with. And because as we've mentioned, many of these are just struggling organizations or law firms. But, you know, one of the things I've come to realize, at least, is that at a domestic or local level, public awareness is the most important thing. I mean, just really when people learn about this, when people understand it, they want to make reforms, and the reforms take that public awareness. And so getting involved in your local organizations in terms of educating your community, which most of them are giving you the opportunities through social media and other means.
Thank you very much. And maybe then turning to a further question, there was a wish to hear from any of the speakers a story about a specific case which illustrates the challenges mentioned by the panel.
I'll grab that one. It's a case I referred to in my remarks, was a case that changed my life. I had read about a young woman on death row in Chicago who had been sentenced to death on a plea bargain. And I was so shocked that someone could get the death penalty without a trial, and how it made no sense that there could have been an agreement for death without any due process, that I went and met with her on death row, and she told me she was innocent. And I then went back and told my first year criminal law students at the law school I was teaching, there's a woman on death row. She says she's innocent. Who wants to help me out? And we started investigating her case and found out she was in fact factually innocent. And that case completely changed my life. I quit my job as a law professor in Michigan, and I started doing this work because of that single case. I just could not believe that in the United States of America, a 21-year-old person could be sentenced to death who was innocent. And we've now freed almost 200 innocent people from death row in the United States. And piggybacking on what Mark just said, I think another thing that's important for average citizens is our entire system is run by average citizens who ultimately make these decisions when they sit as jurors. And what we've seen in the United States is, after this decades of innocence work, that jurors now are not as willing to sentence people to death or sentence them to prison without seeing much more proof than we had in the past. So I do think this movement has had a heavy impact on the general population and how they see the criminal justice system. And that's what leads to reform ultimately through the political process.
Maybe I'll jump in with a story that does not have a happy end, and a case that we lost in the Israeli Public Defender's Office. It was one of our largest efforts in recent years. We represented a client that is still sitting in prison since 1995, who was convicted of murder, and we conducted an extremely thorough investigation of the case. It was a person who was arrested and charged with the murder as a result of being a drug addict who committed burglars in the area where the murder took place. He was interrogated while being under the effect of drugs and gave a confession at that time, which is, I'm sure, a common tale in many jurisdictions. He gave the confession because he wanted to get out. He told the police that he'll show them where the gun is if they'll just release him for a few hours. And he wanted to get his next drug supply, and as a result was charged and convicted of murder. Convicted of murder, by the way, by a panel of he sat before a panel of 3 judges. 2 of 3 judges convicted him, which is one of the differences between different legal systems, because we have a majority rule that convict also of serious crimes like murder. Now, the main piece of evidence was nylon stocking that the burglar wore on his head while breaking into the house where the murder later took place. And we asked to receive that nylon stockings in order to run DNA tests, which were not initially done on the stocking. The prosecution refused to hand over the stocking. This went back and forth for 2 to 3 years. They claimed that examining the stocking would harm the well-being of the victims of the crime, and therefore we cannot examine the stocking. And we had to turn to the Supreme Court to request to examine the stocking. Actually, the widow of the deceased read in the newspaper that it was her well-being that was protected by not handing over the stocking, and it soon became apparent that she was never asked what her feelings were about examining the stocking, and she wrote a very angry letter to the court saying no one asked her, and if there's any doubt about the identity of the murderer of her husband, she was the first ones to know it. So prosecution had no alternative but to agree to hand over the stocking. By this time, the stocking was lost. We never recovered the stocking. They could not find the stocking anymore in the offices of the relevant police station. And we had to proceed with trying to exonerate this person without the benefit of having being able to examine the stocking. And to cut a very long and sad story short, our request for retrial was denied, and a person that we firmly believe is innocent is still sitting in prison. And so this, I think, is a story which is not uncommon and sort of can portray many of the difficulties organizations such as us face around the world.
Thank you, Professor Godse, Professor Brooks, and Dr. Anat, for sharing both positive and negative stories illustrating the challenges of obtaining exonerations. We at UNODC, I wanted to mention, are working on the issue of coerced confessions, developing a tool on investigative interviewing. So this is one issue in addition to legal aid on which we are very actively involved, and which have a direct relevance to these challenges of addressing wrongful convictions. And with that, I think we have reached the end of this event, which I hope our participants have found as interesting, inspiring, informative as we at UNODC have found it. And I want once again to thank our speakers, the distinguished experts that shared their very valuable experiences, and thank all the participants for joining us today. Thank you so much.
Thank you.
Thank you very much.
Thank you.